Yeah, thanks for that. Awesome. Welcome to uh, week one tutorial for contract B. We've just had a little look at the RL process and at expectations for the term. If you're interested in looking at that drop-in session, I will make the recording available for you after we have finished the main tutorial. Okay, so what I will do is once again share my screen, and I might just pop that away. All right, so let's have a look now. All right, let us have a look at the contract animation. There it is. This is the animation that was set for this week's tutorial. In case you have had, you haven't seen it yet, they hide on the Moodle site under materials. So you'll find the week one tutorial question under the weekly materials, and then you'll find the link there to the animation. Okay, and then you'll find, generally speaking, the questions underneath. Okay, so let's have a look at that animation. I'll get it going.
Please have a seat, Mitchell. Actually, I'm generally known as Lord Mitchell of the Seven Golden Orbs, but you can just call me Mitchell if you wish.
Thanks. Do you have a legal problem I can help with?
Indeed I do. No doubt you would be aware that the author Jordan Roberts has recently completed the most recent Wheel of Thrones book. It's called On the Limb of Prophecy. Have you read it yet?
Actually, no, I haven't.
You'll love it when you do. It's his best yet. Anyway, recently I found out that Jordan Roberts was going to do an impromptu book signing right here in town. Did you know that?
No. Somehow I didn't hear about it.
Seriously? You missed out. Anyway, the book signing was meant to be at 10 o'clock, but at the last minute I couldn't find the jeweled scabbard for my sword of justice and heritage. I wanted to go in costume, you see.
I'm sure that was very impressive.
You know it. Anyway, with the delay finding my scabbard and the fact that the digital watch just wouldn't go with my warrior costume, I lost track of time and I arrived just after the book signing had finished. I was devastated.
I'm sorry to hear that, Mitchell. It must have been disappointing.
Yes, but all was not lost. Next thing I knew, some guy was waving to me from a nearby coffee shop. He was in his late 40s, had a beard, dressed for business. I went over and he introduced himself as Jordan Roberts. I was stoked. I did a double take. He didn't look exactly like the publicity shots on the back of his book, but then again, who does, right?
That makes sense. Go on.
So this guy tells me he is only allowed to sign copies of the book at official signings, but he has one in his bag which he signed earlier. It retails for $25 unsigned, but he would let me have it for $100. I thought that was a bit steep, but it was a once-in-a-lifetime chance. I paid him the money, and he added my name above the signature in the book. He seemed like a really good guy. I pulled out my phone and he was happy to pose for some pics with me. Anyway, I rushed home and put the pics up on Facebook. My friends were rather unimpressed though.
Aren't they fans of Mr. Roberts?
Oh, they're all super fans. That's why they were unimpressed. Turns out they were all at the book signing, and this guy who I gave $100 to was definitely not Jordan Roberts. I got completely ripped off.
Do you know who the person was who actually signed your book?
Yeah, he's some guy who works in a menswear store in town. I went to him and asked for my $100 back, but he just laughed and said that I'd agreed to the price. But I only agreed because he said he was Jordan Roberts.
That's quite a tale. Let me think about what we might do.
Okay, so that is our animation, and then who has managed to do the readings for this week? I know there's a few.
Amanda, it's Josh. I managed to get through half of it, so I'm quietly confident that I would know whether he's got a leg to stand on or not, but I'm not 100% certain.
Awesome. I love it. Okay, so we have at least somebody else that will that will chat with me, because let me tell you, my voice gets boring. Oh, here we go. Hang on, we've got a chat. Are we still finding it hard to... Are we okay to hear me now? Okay, Diane, no worries, mate. Good, Sariella. Excellent. We're all good now. Okay, no worries. So, the questions. Is Mitchell's mistake here? Do we need to go through a cook's tour of mistake? Let's briefly go through a cook's tour. We have obviously 3 kinds of mistake. Tell me a few things about unilateral mistake. Anything that rolls off the top of your head.
Usually the word deception would come up to it, so I think I've got it right here, where one person knows that the other has made a mistake and are happy to continue with the second contract. And they've also made some sort of effort to conceal the mistake, or at least hide the mistake made by the other party.
Aha, nice. And the cherry on top. Oh, I've got lots of people jumping in. Oh my goodness, this is a lecturer's dream. Can we do did you yell out a case there for me? Tut.
Sorry, my memory's not that good.
Hey, look. And woohoo, Sinead. Turner and someone. That famous case of Turner and someone. I know it. Oh my gosh, Miranda's even given me a citation in the chat box. That's awesome, guys. Awesome. Okay, so that's unilateral. Now, is that the kind of mistake that's made here?
I didn't hear any mention of the other guy, the Robert, or whatever his name was, saying that that's the only reason why you're going to get this book or whatever. So I wouldn't have assumed that it was unilateral, but I heard the first 10 seconds of it.
Yes. See, I've got yes. Yep. Yes. I have someone. Mm-hmm. Smarty. Mistake as to identity. Okay. Let's unpack that a little bit then. In fact, let's get rid of the other 2, because I think we should probably put them to bed. What are the forms of... hang on a second. I felt this was more like Lewis and Avery. Nice, Michael. Lincoln says he should have known the purchaser was only purchasing in reliance on who he said he was. Okay, we will talk about that. All good points. Let's just do things methodically. Common mistake. How many of the parties, in terms of a common mistake, how many of the parties are mistaken? 2, Tam says. Both, yes. Both parties are suffering under a mistake. Okay. That's the second question I was going to ask you. You're already jumping in. This is awesome. So I was going to say, how many mistakes have been made for a common mistake? And the answer is 1. 1 mistake. They both suffer under the same, that's right, Tam, mistake. Okay. So I say common mistake. I normally say common mistake is 1 mistake by the parties. Mutual mistake, I remember that by saying Many mistakes made mutually. Yes? So again, we have two different points of view, two mistakes. Now, it may be that on closer inspection, only one party is mistaken and the other party's interpretation of the contract is actually correct. Yes? But
I'm sorry, but how is the guy pretending to be Jordan Jones, whatever his name is, mistaken? Because he's portraying someone here, isn't he?
he's not mistaken, he's a rogue.
Yes, that's what I'm saying. So how is there two people with a mistake?
I'm going through the different types of mistake that you can have before we fully unpack unilateral mistake, which is down here. The top question relates to unilateral mistake, but I want to unpack the other two first so that we have an idea of where unilateral mistake fits in. Okay?
All right, I didn't catch that part. You're right, thanks.
Yeah. So, so unilateral mistake. Now, the thing that differentiates mutual mistake from unilateral mistake, even in this second scenario, is that neither party knows about the other's mistake. And that's super important because here is a snippet of equity that you'll need to know about. Equity follows the law. You can't just use equity to get around the law. There is a very carefully managed set of triggers that will enliven equity's jurisdiction to intervene. So, generally speaking, where one party's interpretation of the contract is correct, that is the interpretation that will be upheld by the law, and the contract will not be void for mutual mistake. The big thing about the conclusion in law is that a contract will be void. If you're talking about a result in equity, usually the contract will only be voidable. Voidable. What's the difference? What's the difference between a contract that's void and a contract that's voidable? The innocent party may accept or rescind the contract. Yes, Joy is saying from the beginning for void. And Michael says void is now not in existence. Exactly. So the conclusion, if you have a contract that's void at common law, it's an extremely serious conclusion. Because what that means is that contract basically has never existed, as Joy said, and as Michael said. And Michael says voidable means the injured party may either elect to affirm the contract, that's right, or rescind the contract, and again, that is right. But what happens if the benefit of the contract has already moved to an innocent third party before you get a chance, if that contract is voidable only? What happens to your right to rescind if an innocent third party's nicked in there and got the benefit of the contract? Can you still rescind? No. Oh, Michael, that's very sophisticated. Diane says no, and that's correct. You cannot, because there are limitations on the ability to rescind a contract, okay, if it's only voidable, all right? So you need to keep those two conclusions quite separate. And in my first key concepts video this week, I talk about the difference between void contracts and voidable contracts, okay? So go and have a look at that key concepts video if you are still confused. So generally speaking, equity will only be able to nip in, okay, to save the conclusion of a contract being completely void if there is reason for it to do so, okay, because generally equity will follow the law. So if the law has said, look, there is one completely reasonable interpretation of this contract, and that one party has that interpretation, we're going to uphold that. You can't then have equity overriding that conclusion and say, hang on a minute, no, we still think it's voidable, all right? Generally, equity will follow the law unless there is some reason for it to nip in there and offer an alternative. And generally that reason for equity to nip in there will be something that smells like unconscionable conduct, equitable fraud. It's got loads of different names. It's that gut feeling that something's not quite right, okay? So where you've got a mutual mistake, where neither knows about the other's mistake, there's no reason for equity to nip in there and try and offer the injured party some kind of remedy of rescission, because there's been no equitable fraud, improper conduct, unconscionable conduct, whatever you want to call it, okay? So particularly for mutual mistake, where there's no knowledge about any of that happening, equity will follow the law. And if the common law says, you know, the contract's still perfectly valid, it'll be held valid, okay? If the common law says no, in this particular case, we can't make sense, there's no point of view that's right, there is two mistakes, then, you know, the contract will be void. Can anybody, and 10 brownie points and 5 gold stars if you can tell me the name of the case that talks about mutual mistakes where the court actually couldn't work out an objective meaning for the contract, and it had to do with 2 ships, and they were both called the Peerless, and the contract said that they were going to buy and sell some cargo that was on ex-Peerless from Bombay. But there was one ship called the Peerless that was leaving in 1 month, and another ship called the Peerless, wouldn't you know it, that was leaving in another month. 2 completely different ships, 2 completely different cargoes. One party thought it meant that ship, the other party thought it meant that ship. At cross purposes, couldn't make sense of it. Nice! Sorry, Ella, that's awesome. Raffles and Wicklehouse. Yes, that is the case where the contract was void at common law. Very serious conclusion there. Okay, so now we finally get to unilateral mistake. And as we said before, normally deception does come into it. Yes, exactly. One person knows a mistake was made and was happy to continue or receive benefits under it. Made an effort to conceal the mistake. You can see there the smell of something wrong. And that's normally a red flag that equity might step in to help out with the situation if the contract was otherwise held to be valid at common law, okay? Now, there are a number of different kinds of unilateral mistake. Can you run through those with me? So there's a... Good. Mistake as to identity. So obviously there's just the identity, subject, and nature. Yes, or mistake as to subject matter, identity, and nature. Shanae says, and sorry, Ella, subject matter, yes. So we have 1, yet It's an already signed book. Hang on, Joshua, we haven't got to applying just yet. Woo, Tam, right? Yes. I'm going to get back to that one. Tam just said something about non est factum. Okay, hold on just a second. I love this cracking case. Okay, so we have unilateral mistakes as to give me some Latin. Give me some Latin. Haha, yes, interpresentes. What does that match up to? Unilateral mistake as to existence, race extincta, unilateral mistake as to title, race, sua, and unilateral mistake as to identity. And there is a, how do we work in the interpresentes issue? Tell me about a little bit about mistakes as to identity, because there are a number of different kinds, aren't there? And it has to do with the way the contract is concluded. Think about the case where the rogue wrote the letter and made it look like he was from a company called Blancaron. Ha ha! Joy's got it. Okay, so we have mistake as to identity for contracts concluded by writing, contracts concluded face to face. Now, Cundy and Lindsay, that's it. Yes, thank you, Cundy and Lindsay. Awesome. Sorry, I was on fire here, Cundy and Lindsay. Okay, contracts concluded face to face. So generally speaking, what's the go with face to face? And this is where our Latin comes in here. You are presumed, there's the big one. Usually there is, the Lincoln says, there's a presumption that's meant to be made with the person in front of them. That's it. Presumption that you intend to make the contract with the person in front of you. That's exactly right, yes. And Tam and Lincoln says it is rebuttable, exactly. And that's where we have that lovely Latin. Okay, this presumption is rebuttable. Now, what was the case that talked about, that's most remembered for first talking about this rebuttable presumption? And it was about an emerald ring that a jeweler very stupidly let a rogue take away because he thought he was someone of noble descent. Aha, Tam's got it. Phillips and Brooks. Okay. So, there they said that just looking in a phone book wasn't enough to rebut the presumption, was it? Woo! Presumption. My fingers aren't working. Okay, so in order to rebut the presumption, you've got to actually show that you only wanted to contract with a particular person. You've got to do sufficient things to make it very clear that's the only party that you wanted to actually contract with. Let me take you to back up here, because I want to add in something here. What are our elements where we have mistaken identity? You have A. What does the text tell you that our elements are here? There we go. I'm looking at paragraph 14.220 of the text, if you've got your text there. 14.220 on page 570 of the old text, and page here we are. Common mistake. Oh, sorry. Common. That should be common. Oh boy, what am I doing here? These should be up here. Sorry if I've... Let's put that there. Okay. Sorry, the race extinctor and the race sewer should be up there. So, elements. Let's go. A in 10. Only 2. The other person was aware of the mistake. They didn't inform the other person. Yes, although that's more... Now, this is where I wanted to give you a bit of a background here. And unfortunately, I don't want to give you a bum steer. The Latin stuff that I was getting carried away with up here belongs to common mistake. But in terms of a unilateral mistake, what I wanted to tease out for you was the different forms of unilateral mistake. So there can be a unilateral mistake as to identity, but that is obviously carved up into contracts concluded by writing, contracts concluded face-to-face, but there is also a unilateral mistake generally, and this is where there's no issue of identity involved, and that was Taylor and Johnson. So in Bell and Lever Brothers, they say that it has to be a fundamental mistake, and it has to what? It has to essentially go to the foundation of the contract. It has to almost pretty much make performance impossible, or make the consideration failed without it, okay? That was in Bell. Yes, then we had that problematic case of Soleil and Butcher, where Lord Denning went on his rant and said, hang on a minute, even if the contract is still valid at common law, not void, it could be voidable. Can anybody tell me anything about Soleil and Butcher? What were the facts of Soleil and Butcher? Rent capping legislation. Awesome. Yes. So we had a lease of premises. And both parties thought that it was, in fact, the rent was capped, but it wasn't. And then we had that case, and the court held it was still voidable. that case was discussed by Taylor and Johnson. Now that, importantly, was a case of unilateral mistake, not common mistake. So you'll see why I say it can get a little murky, because you will often find cases where you can argue that something is either a unilateral mistake or a common mistake. Okay? What you have to get straight in your minds is how willing a court will be if the common law would otherwise consider that the mistake is not sufficient to render the contract void. So the contract's still valid at common law. How willing a court would be to jump in and say that a contract is still voidable in equity. Okay? And you'll have this long discussion. There's a long discussion in the text about this. Taylor and Johnson, back in the section on common mistake in your text. And that is at, I'm just trying to get the sections for you. Here. Okay, so 14.4.2 in the 2013 text, and 14.4.2 equity at page 573 of the new text. And you'll see that there is a discussion about Solé and Butcher, and the case law crosses over from common mistake there into a discussion of Taylor and Johnson, which was a unilateral case of unilateral mistake. It's a very interesting area, and it's one that I want you to guys to have a think about. So you need to have it straight in your mind when you will see an instance of common mistake and when you'll have an instance of a unilateral mistake. Here, it's a very clear case of unilateral mistake because it's as to identity. It won't always be like that. It may be a mistake that's a little bit more grey. And so in those circumstances, if just the one party is mistaken, it's going to be a unilateral mistake as to subject matter. If both parties are mistaken, then it's going to be probably a common mistake. And you will see, particularly when you look at a case called Australia Estates, you have a case there where there was an argument that a mistake was a common mistake, when in actual fact it was just a unilateral mistake as to subject matter or substance. And so that's why you really need to tease out what the most likely interpretation will be, where it's not something quite so clear as what we've got, which is mistaken identity. Okay, so I guess you can gather from that little discussion where we will be headed with assignment number 1. Okay, so have a look at all of that development of case law. I probably would strongly suggest that you get your hands, in fact, on the 2018 version of the text for this particular chapter, and there's electronic copies available for you in the CQU library if you need to just download that one chapter. I would strongly advise that you do download that particular chapter if you only have the 2013 text, because there is some discussion on this point that will be that will be relevant for the assignment. Okay, so where we have the comparatively much easier issue of a mistaken identity. Usually you'll have the rogue pretending to be someone else, and it will either be done in writing or it'll be face-to-face. Where you have it face-to-face, there is that presumption that you're going to be contracting with whoever's in front of you, but it is rebuttable. So let's do a quick. Is Mitchell's contract tainted by mistake, and therefore is it going to be void or voidable? Just put it that way. Thanks, Joshua. Okay, so rules. We have here. We'll put them up here and then we'll copy and paste them. A intends to contract only with a particular party. Identity is material. A intended not to contract with B, but with C, and B, yes, thanks, Natasha, knew this. There's your elements, okay? Elements are the same, whether it was concluded in writing or face-to-face. So that's why I said I just wanted to jot them down up here before we move them down to our rules section. Okay, and because here it was face-to-face, so we can just say there is a presumption. Yes? Those bullets have gone woofy, haven't they? Okay. Nicely done. You would probably want to put in Bolton and Jones was that one, wasn't it? Yeah, I'll definitely upload this. Bolton Jones. A intended. Now that one is coming. And B knew this. Okay, so then we also have that presumption there. That's all you need for your rules. No more requirement than that. Okay, so how does it all work together? What do we say here about what happened? How would you start this off? Natasha, is your mic working? Do you want to yell out anything? Oh, it's not still. Okay. What I will do is I will take you to an IRAC that I have marked. And that's probably a little long for the issue. The issue is whether the purchase of the book is a unilateral mistake. I just said, is Mitchell's contract tainted by mistake? Start with issue, rule, and then apply it to the situation. Yes, that's it. Exactly. Sorry, Ella. So the issue is whether the purchase of the book was a unilateral mistake, mistakenly identifying the rogue as Jordan Roberts. Now, I think now I've got another example here. Natasha, do you mind if I bring yours up for a second? I can bring, are you sure? I have got another one here that I can use. I'll just put here. There was another one here. So the other one I had was this. The issue presented is whether Mitchell has any remedy against a menswear store attendant who posed as an author, Jordan Roberts. After an impromptu book signing, which Mitchell missed, the menswear store attendant convinced Mitchell that he was Jordan Roberts and offered to sell him a signed copy of his book. Now, can you see the if? Yes, that's a decent recount of the facts, but it doesn't actually tell me the legal issue. The legal issue is whether the purchase was a unilateral Mitchell by mistake, a unilateral mistake by Mitchell. And that's really all we needed to put here. Okay. Rules, we have the same rules that have been cited here. A, must have regarded the identity of the party as material, which is what we've put. Okay, we've got a nice little citation there, Bolton and Jones, okay. Mitchell intended not to contract with the rogue, but with someone else. Yes, we've got that in our rules as well. And B, knew this, okay. That intention was known. So they've done the same thing for rules. Application, here. And I think this is often a good way to start off your application. Mitchell's action to go to the book signing to get a book signed from Jordan Roberts indicates that he wanted to get a book signed from him alone. Okay. Yes. Anyone have any other views? Is it a material part of his contract? Mitchell should have been more careful. Ha ha! I was hoping someone would say that. Yes, Mitchell will need to show that he intended to contract. Okay. However, and there is a rebuttable presumption that because the contract was concluded face to face, he intended to contract with the person in front of him. Yes? So, he needs to show he took sufficient steps to ensure the person was the person he wanted to contract with. Then what you need to do, and this is the beauty of your analysis coming out okay? You need to show the lecturer you know the case law in Phillips Brooks. Just looking in a phone directory to check a person's identity was that sufficient? Was that sufficient? Not sufficient. Haha, thank you. Thank you, thank you, thank you. Not. It was in Ingram and Little, but that's a bit of an anomaly, that case. Similarly, and this is the big gold ticket case you'd want to be mentioning here. Thank you, Natasha. Lewis Avery. What happened there? Now, you need to take that naughty toddler marker and you need to tell them enough of the little snippets of facts from that case to show them that you know what that case was about. Going to the post office to check identity was sufficient. That was in Ingram and Little, Natasha. That was in Ingram and Little. In Lewis and Avery, a rogue pretended to be Richard Green, the actor, and he showed an official-looking pass to the victim. Yes? It was it sufficient to look at the rogue's own purported fake ID? Was that sufficient to check that he, yeah. Yeah, it was not sufficient to take the rogue's own word for it by simply checking the pass. Yes? Now, here is the craft of your analysis coming in again. What's the very next thing that you want to say? You want to tell the court basically that, or convince you, whoever it is, that Lewis and Avery will guide the court in this situation. So how are you going to best do that? What's the very next thing we want to say? If it looks like a duck and it talks like a duck, quacks like a duck, waddles like a duck, it's a duck. Do you get my drift? So you're saying in these, Lewis and Avery is applicable. Yes. Convince the court that the client took actions to verify the identity. Yes, if you are trying to find a way out for Mitchell. However, you can't always give your client the advice they want to hear, can you? Signature in the book. What steps? Yes, exactly. So let's just have a little look. Here, Mitchell, what did he do? Did he take any steps to verify? What happened? He took his word for it. Yeah, took the rogue's word for it. And he even had brief doubts because the rogue didn't look like the publicity photo. Yes, thank you, Diane, exactly. So, unfortunately for Mitchell, what's our conclusion here? Contract stands. Contract So, sorry we're a little late. Conclusion. Mitchell will not be able to get his $100 back. The contract is valid. Sorry about my messy screen. I just want you to see what this other student has done because it's useful just before you run away. So in this case, oh, thank you, David. Awesome. Mitchell's actions go to the book signing. Okay. They think that it indicates he wants to just contract with him. Similar to Lewis and Avery, where a rogue who'd identified himself posed as Richard Green. He allowed the car to be taken away by Richard Green. In this case, see, they've discussed the case that's most useful, and then they've immediately gone to discuss the facts at hand. In this case, the rogue called Mitchell over to the coffee shop, falsely misrepresented himself. He's agreed to the terms, handed over the money. He had doubts about the publicity shot, but went ahead anyway. Didn't do enough checking there. This is what happened, obviously. The rogue altered the signature in the book, blah, blah, blah. The actions led Mitchell to have an honest and reasonable belief that the identity of the rogue was Jordan Roberts. Yes, it did. The rogue knew, but you're not going to discharge the rebuttable presumption because I don't know why they went into Ingram and Little so much. And I've said here, compare Lewis and Avery, which is what we went and did. No attempt was made to verify Green's ID. Questions? Questions? Thank you, Lincoln. Oh, you guys are awesome. Cracking Tute. I will put this example up. I think it's quite good. I think I have another one in mind that I'll probably also put up as well because it was probably maybe a little more clear on the presumption issue than this one. All right. I hope that was useful. I'm sorry we ran a little bit over time. I'll put the recording, and I hope there was a recording. Anyway, if there wasn't, I'll put last time's round. And thank you very much for coming. Have an excellent evening. I'll stop sharing now so I can see all of your lovely... there we go. Phew, it was recording. Thanks, guys. Go and have a nice dinner, cup of tea, glass of wine, unwind. Weekly questions aren't marked and counting to percent. No, they're not, Joshua. No, but if you do want them marked just for practice, no problem. Thank you, everybody. Okay, bye, guys.